Hi, I'm Steve Carlson. I'm running for president, and I'm the petitioner in this election litigation at the U.S. Supreme Court, seeking to restore civil rights and restore the Minnesota Independence Party to the general election ballot because of severe constitutional violations in its elimination. Governor Dayton has thus far refused to respond. The Democrats in Minnesota are insulating issues like the corrupt use of public information to help just Democrats, the exclusion of white male and straight votes from the delegations to elect House members, senators, and the president, and refusal to enforce election laws by Minnesota courts, and helping Al Franken to avoid having to debate in public with the elected nominee of a major political party. In order to protect this from going forward to the U.S. Senate, as called for by Minnesota law and by the U.S. Constitution, Dayton slipped an election certificate illegally to Franken to blow up an election contest, and he lied to the U.S. Senate. Now he hopes the U.S. Supreme Court will do nothing. But here's the argument presented in a cert petition to the U.S. Supreme Court. There is some legal discussion here, but I think anyone interested in free and fair elections in the United States, this is not just about Minnesota, will find it interesting and help you learn more about how our elections are being corrupted year after year. In another video regarding the fight for voting rights at the U.S. Supreme Court, I presented to the court facts necessary to understand and grant the petition. Here I present the incredibly important reasons in the form of an argument why the petition should be granted and why this certificate of Franken should be withdrawn and the contest allowed to proceed to the United States Senate. Because of limited technology, I may have to break this argument up into multiple videos. Here is that argument. I begin with 9/11. They think freedom is our weakness, but it is our strength, is a phrase which has been invoked in such a central event in our history as 9/11. But beyond this court's guarding and securing our rights, based on our cherished U.S. Constitution, our only other secular source of freedom, our strength, is one of those specific rights so secured, that is to say, the vote, in free and fair elections like the one for senator from Minnesota challenged here. This court shares the responsibility of securing that core right with the U.S. House and the U.S. Senate, and in the executive branch, entities such as the Department of Justice. To paraphrase this court in Anderson, burdens like those described infra that fall unequally on independent candidates or on new or small political parties impinge by their very nature on associational choices protected by the First Amendment and discriminate against those candidates and voters whose political preferences lie outside the existing political parties, unquote. And that is precisely what this case is about, securing that right to vote with the First Amendment rights for individual voters, their party, and petitioner as their nominee for Senate in 2014 and candidate for president in 2060. As such, this case brings these two strengths, the political basis of the vote and the legal basis of the vote, together, and both are in jeopardy if they cannot be reconciled in this case. This year, when 45% of the voters identify as independent, not Democrat and not Republican, and 8% with a third party such as the Minnesota Independence Party, call that IP, which is in limbo, the partisans combined are in a distinct minority, 47% to 53%. And so this court's aid, based on your ruling in Anderson versus Celebrezze, that's 460 U.S. 780 from 1983, is called on to stop IP, a leading independent voter vehicle in the nation, from going under as a Minnesota major political party, as the direct result of the very unconstitutional practices which gave rise to the Anderson ruling, burdens that fall unequally on independent candidates or on new or small political parties. And that aid is called on here for this court to command Minnesota to follow our Minnesota election law and the U.S. Constitution by withdrawing the wrongfully issued Franken election certificate and allowing this contest to be completed and sent on to the U.S. Senate for disposition as the sole judges in the contest. But then, as suggested in Powell versus McCormick, that's a D.C. Circuit case from 1969, for this court to review the actions of the U.S. Senate, or inaction if that occurs, for constitutionality. For this reason, and reasons argued infra, the court should 1. Request a response from Minnesota to this petition, then 2. Grant the petition and reverse Minnesota's decision and remand it back to the Minnesota High Court, 3. With instructions to command the governor to void the election certificate for being unlawfully issued December 19, 2014, while a contest was pending. 4. Void the election results and restore the major party status lost as a result of those results. 5. Strike down as unconstitutional the new 2015 law repealing the tolling provision during contests. 6. Reopen the contest under Minnesota law to certify evidence on the challenged practices and invalidity of the election. And 7. Allow it to go to the U.S. Senate for disposition. 8. Restore the Minnesota Independence Party as a Minnesota major political party pending the disposition of the case on the grounds that the practices brought before the Minnesota Supreme Court and now this U.S. Supreme Court are in violation of the constitutional practices referenced above and as argued further infra. We'll start with the protections of the 14th Amendment and Guarantee Clause, Article 4, Section 4, Clause 1, both in the U.S. Constitution. This court should command the state of Minnesota sitting in the Supreme Court and the Governor Mark Dayton and the Secretary of State to follow the applicable Minnesota election laws regarding the release of the election certificate, including to the U.S. Senate, the conduct of congressional office election contests, and tolling of the certification process pending completion of the contest and submission to the U.S. Senate. Because 1, it is the requirement of the operation of Article 1, Sections 4 and 5 of the U.S. Constitution, and 2, the United States, including this court and the U.S. Senate, has a duty to enforce this constitutional prescription of the Republican form of government. Then going to go to Governor Mark Dayton's disregard and repeal of the congressional election tolling provision. On May 22, 2015, while a congressional election contest raising significant issues about free and fair federal elections in Minnesota, respecting the rights of independent voters, was pending, Governor Dayton and the legislature, without public discussion, took away a right from individuals that was granted in the election code. That is to say, that during the pendency of an election contest under 209-12 congressional office, the issuance of the election certificate would be tolled, that is to say, barred. See Minnesota Statutes 204C.40 subdivision 2, 2015, but it's really applying 2014. Now, the purpose for this statute is to ensure that no one takes office unless as a result of a valid election. See Sari versus Gleason, 1914 Minnesota Supreme Court case, requiring validity of election to take office. That simply excludes a candidate employing unlawful means from reaping the benefit of his own wrong. He must use honest means to obtain it. This is cited in Pavlak versus Groh, a Minnesota Supreme Court case from 1979, and in Odegaard versus Olson, and that was cited in Franken versus Pawlenty, in the case in 2009 where Al Franken sought to enjoin Governor Tim Pawlenty to issue him a certificate while a Chapter 209 contest with Norm Coleman was still pending. In addition, Smiley Vs Holmes, U.S. 1932, another Minnesota case at the United States Supreme Court, stressed the broad grant of authority to the Minnesota legislature when fashioning an election code for Congress. They gave no such discretion to the state courts, and certainly not to engage in common law and equitable decisions overriding statutes of limitations as the court did in 2012. That court never even considered a single election practice, and that is why the Chief Justice was quoting from a federal district court case. This repeal of the tolling provision by the governor is a clear attempt to violate the election code by undercutting the manner prescribed for electing members of the U.S. Senate and U.S. House in Minnesota, and in fact is deliberately designed to take away from the voters the same protection of the integrity of the election that they still protect in the analogous law for the elections to the Minnesota legislature. In other words, a valid election is deemed necessary to assume a state office, but not to assume federal office. And this further and deliberately undermines the powers reserved by the framers for the sole judges, the U.S. Senate. That Senate, in turn, has the Guarantee Clause duty to guarantee to the voters and individuals in Minnesota a Republican form of government. So while this recent action removed what for Governor Dayton appeared as a mere inconvenience, having to hear that he violated Minnesota law by issuing Al Franken's certificate on December 19, 2014, while an election contest was still pending, and in 2012 by doing the same for Betty McCollum just days after the election contest in her race was issued, his action has the effect of weakening our freedom, polluting the purity of our federal congressional elections. Finally, it was another nail in the intended coffin for the Minnesota Independence Party, that vehicle for independent voters to associate to support a candidate whose policy views are most similar to their own. Without access to a sound election petition to hold the major parties to valid elections with constitutional election practices, including full enforcement under the Congressional Election Code. And I said see Smiley vs. Holmes, the 1932 U.S. Supreme Court case, and Rodebush vs. Hartke from 1972. Now next, the Minnesota Supreme Court cannot limit jurisdiction narrowly to avoid hearing and determining validity and constitutionality of elections and practices. The Minnesota court has done great mischief by misstating the Minnesota contest and petition law, by wrongfully narrowing the scope of its self-described functions under the CCEC. That's what I call the Comprehensive Congressional Election Code. The Franken versus Palenti, or Franken 1, 2009 opinion contained dicta which seemed to suggest that Minnesota Statute 209-12's language and construction statutorily limits any contest to just the issue of which candidate received the highest number of votes legally cast and is therefore entitled to receive the election petition. However, as its very Franken 1 opinion referred to, Chief Justice Knudsen of the Minnesota Supreme Court in Odegaard versus Olson cited Chief Justice Hughes in the Smiley versus Holmes U.S. Supreme Court, interpreting Section 4 of Article 1 of the U.S. Constitution to stress the broad grant of authority to the state to legislate its comprehensive congressional election code. And Knudsen set out the complete coverage as the steps required to conduct an election. And the scope of the enforcement must necessarily be broad enough to enforce the entire CCEC. Since this CCEC is mandated not by our state's high court, but by the U.S. Constitution, that is to say, the very framers who constructed this nation with a democratic-republican form of government, the Minnesota court simply lacks the authority to cut back the enforcement of the broad and comprehensive CCEC enacted and replace it with its own wisdom or preference. The law has been prescribed, written in advance, and the Minnesota Supreme Court simply are not permitted to rewrite it as they go, which they did in 2009 in their dicta. Its dicta were not even material to the Franken petition, because the Franken contest was limited to just those questions, that is to say, who received the highest vote total. However, the issue of the statutory scope of 209-12 contests goes beyond the scope of that particular Franken contest, and it could not have been simply addressed in Franken 1. it may be addressed here and must be, and this is the case in which you must restate the original standard. Yes, the statute was designed to facilitate the Senate's powers under Article 1, Section 5, U.S. Constitution, but it was not designed and could not constitutionally have been designed to in any way limit the broad scope of Article 1, Section 4, U.S. Constitution. All the court actions available under the CCEC, notably Minnesota Statutes 204B.44D, the election petition statute, and 209.02 and 209.12 congressional office election contests, simply must be and are available despite the overstatement by the Minnesota Supreme Court in Franken 1 purporting to statutorily limit the scope of the contest statute. Voter email issue and public broadcast debate issues. This is getting to some of the substance that I'm trying to bring to the Senate. Minnesota Statutes 13.03 Access to Government Data, Subdivision 1 Public Data, provides in pertinent part that, quote, all government data collected, created, received, maintained, or disseminated by a government entity shall be public, unless classified by statute or temporary classification pursuant to Section 1306 or federal law as non-public or protected non-public, or with respect to data on individuals as private or confidential. The responsible authority in every government entity shall keep records containing the government data in such an arrangement and condition as to make them easily accessible for convenient use, unquote. And that has been the CD, which I purchased. That's the convenient way that they are to provide that to me. Now, accordingly, the voter email addresses, however collected by the Secretary, are public information, public data. And that is why the OSS, Office of the Secretary of State, could hand them out for years, as Nancy Bream offered to me, paying a $30 fee. Certainly the argument adopted by the Minnesota court that public information cannot be given under the First Amendment precedent because a state cannot give out something valuable to a campaign is absurd. In addition, I paid a $400 filing fee to help cover the costs of the state conducting the election. It's all very valuable. Certainly, Chief Judge Michael J. Davis of the District of Minnesota, who wrote an opinion saying this, can himself not usurp the power of the U.S. Senate to preclude this issue from being looked at by the U.S. Senators who have their own duty to ensure a Republican form of government, that is, pure, free, and fair elections for members of Congress. In this case, not only does this limit my First Amendment right to associate and express my political ideas and qualifications to the voters of Congressional District 4 in Minnesota, or the state itself in the Senate case, using these admittedly valuable voter email addresses, but it creates a huge advantage for better organized and better financed national major political parties, like the Democrats and Republicans, who control all the seats on the Minnesota Supreme Court and virtually every judge in the state. It cannot be enough that to survive and meet even the 5% threshold for statewide elections, IP nominees for those offices have a right to associate to support their candidates under the First Amendment. And this absolutely requires that the full scope of enforcement is required to ensure a valid count of those who would vote for such a small party. And this is the Anderson Court ruling, that these decisions by the two big parties must not fall unequally on us as individual voters in small parties, or they must be justified by the state. No court, even when Davis's federal court considered Anderson, has asked the state to justify this. The two major parties use all social media, but when I use social media and don't pay the TV, radio, and newspapers for paid advertising, I'm not a serious candidate. Plus I sing and rap. Including email, they use email, and just allowing the use of this public information under state law would even up that playing field. The federal decision in 2013 deliberately protects people who make millions of dollars selling these emails or email addresses when the voters have voluntarily submitted them to the state as public information. This comes into play significantly when, in the case of the CBS WCCO Larry Jacobs, And this was in the CBS brief submitted to the Minnesota Supreme Court for its October 27, 2014 action on that petition. Jacobs expertly informed the CBS organizers of this U.S. Senate debate, public broadcast debate, from which I was excluded, that I did not reach the 10% threshold he recommended to determine the cut. I did poll at 13% by Gravis Marketing in July against Franken and McFadden, and this issue is involved in the motion for injunction still sitting in Justice Breyer's office pending the cert petition. But it seems illegal that a major political party that needs 5% of the vote to stay on the ballot from year to year needs to prove to an expert for a public broadcast debate organizer that they're polling at 10% in the polls. That's twice what 5% is. Why would that be required? Obviously, being excluded from the debate is going to reduce exposure, but also depress voter interest, not only in the debate, but in voting at all. Also, I suggest that based on the FCC disposition of my complaint on this, that the court find that because of this kind of lax enforcement or even disinterest, that it is a barrier to First Amendment rights for small and new parties, and that they should be able to go straight to court instead of mandatorily exhausting this administrative remedy, supposedly. Now, perhaps that's something for the U.S. Senate to take up. I could have got to the Minnesota court to discuss this with CBS. I filed it October 1st, 2014, and didn't hear back until just days before the next scheduled debate. However, the fact that an election petition might not have been appropriate to ask the Minnesota Supreme Court to consider opening a public broadcast debate simply does not mean that the Senate should not look at this when brought in a contest. The petition and motion to open the CBS WCCO U.S. Senate debate to the IP is distinct from the instant petition dismissed by the Minnesota court, because this is to allow a contest to go forward to the U.S. Senate. Further, it is still not clear why the Minnesota Supreme Court could not have heard the petition under the First Amendment, as did the Ramsey County Court in Moore versus MPR 2002, 2nd District, when Jim Moore was the IP nominee for Senate against Walter Mondale and Norm Coleman on the tragic death of Senator Paul Wellstone. Requirements of the U.S. Senate for a certificate of election. In a letter to then Secretary Ritchie from Nancy Erickson, Secretary at the Office of the Secretary of the United States Senate, as Appendix A, Exhibit 3, the Senate instructed then Secretary Ritchie that, quote, enclosed is a copy of Senate Rule 2, which contains the wording for the certificate. This language must be adhered to, or the certificate will be rejected and returned to the state for recertification, unquote. Clearly, under Senate rules, and this court cannot act for the Senate, but they provide for recertification in a case like this, and that could be a very likely outcome should the contest go to them. In fact, the governor should contact them, but has not to pull the certificate. This court would be justified in instructing the state that because the governor did not comply with the effective 209C.40 subdivision 2, it was unlawful to release this certificate to the Senate. In fact, Senator Al Franken should correct this wrongful release himself and work with the Senate to examine these unconstitutional practices. It is not the case, as urged by Secretary Simon and the Minnesota court, that practices affecting the validity of a Senate election outcome should not be examined for any election. In other words, this happened in this election, regardless of what the Minnesota Supreme Court may be talking about. They need to talk about this. Now, in turn, the Senate rule language ID identical says, in relevant part, quote, this is to certify, this is what they're saying they have to follow. This is to certify that Al Franken was duly chosen by the qualified electors of the state of Minnesota, a senator from said state, to represent said state in the Senate of the United States for the term of 6 years, unquote. The election certificate issued in violation of the Minnesota law and the Constitution contains this language. This is to certify that on the 4th day of November 2014, Al Franken was duly chosen by the qualified electors of the state of Minnesota, a senator from said state to represent said state in the Senate of the United States for a term of 6 years, unquote. The certificate features the seal of the state of Minnesota and signatures of Governor Dayton and Secretary Ritchie. And a handwritten note shows Governor Dayton signed it on December 19, 2014 at 4:26 p.m. Further, the cover letter, and the contest was still going on. There were submissions due to the panel, 3-judge panel set up by the Minnesota Supreme Court in that contest. Further, the cover letter, Appendix A2, sent to the U.S. Senate on December 19, 2014, with the certificate specifically and falsely states, quote, "Dear Madam Secretary, in accordance with Minnesota Statutes, Section 204C.40, Subdivisions 1 and 2, I have prepared the enclosed certificate of election, countersigned by Secretary of State Mark Ritchie. Please note," it goes on, "the certificate contains language identical to language set forth as requested by your office," unquote. But while the language conformed, the substance of the statement uttered did not conform to Minnesota law. That is to say, it was false, because it represented to the United States that there was no contest pending, because 204C.40 Subdivision 2, 2014, reads, "Time of issuance, certain offices. No certificate of election shall be issued until 7 days after the canvassing board has declared the result of the election. In case of a contest, an election certificate shall not be issued until a court of proper jurisdiction has finally determined the contest." This is what Al Franken said he didn't want them to do in 2009. He didn't want them to do it this time either. "This subdivision shall not apply to candidates elected to the office of state senator or representative." Well, this is not for that. And by the way, this "in case of contest" is what has been stripped out by a repeal enacted by Governor Dayton in May of 2015. Now, as a result, the statement conforming to the language of Senate rule that Al Franken was duly chosen is false, because the statement itself did not follow the legal requirements of the state as required by the U.S. Constitution. And this was intentionally done to violate said state's tolling provision, because surely Secretary Ritchie, copied on the cover letter, was aware that under the law of Minnesota, the tolling provision would not allow the certificate to issue to the U.S. Senate Secretary until the pending contest heard December 18th, just the day before, until a court of proper jurisdiction has finally determined the contest, unquote. Before discussing the procedural moves of the state in its courts and executive actions in stopping this contest and issuing a certificate based on a partial contest subject to various types of review by Minnesota courts, I want to stress that the entire proceeding consisted of Minnesota judges wrongfully acting as judges in a case that was not within its power. The powers of the Minnesota courts were strictly defined, limited by the state legislature's enactment of the election code for congressional office, and this overlaps with the election code for state offices as well. See Smiley Vs Holmes. In this case, the duties concerning an election, to use the words of the election petition, were clear, and the Minnesota courts, if they exceeded that, which they clearly did, were ultra vires and usurped the powers of the real judges, the U.S. Senate. I have stressed in these courts that this was orchestrated by a member of the Senate itself, Al Franken, one of the judges acting in conflict of interest. Does this mean I assert that a senator may not take all legal actions to contest as a contestee? No, but he may not work with partisans like DFLers Ritchie, Swanson, and Dayton, or with any state officials to alter the election laws, the manner in which senators are chosen, which are prescribed, that is to say, written before the election takes place. And Senator Franken and his counsel and the state officials and their counsel have done this, and Minnesota courts have willingly colluded with them to rewrite the election law as they go along. And when they do that, they rewrite the Constitution. They deviate from constitutional requirements under Section 4, usurp state power under Section 5, and take Senate power under Section 5, and take void and voidable actions which do not exist in law and constitution, but which are an absolute act of will. I have called this corruption. The repeal of the tolling provisions, which the state violated December 19th and then thereafter repealed, was an unconstitutional act. It apparently is intended to influence this election litigation, to make an argument that when Gildea denied the petition for rehearing, the law didn't require tolling. But for future elections, this repeal violates the Constitution, violates due process, and violates and strips away the rights of individuals, because it is an individual who under current Minnesota law files an election petition, and it is any eligible voter, including a candidate, who files a contest. Even though Governor Dayton on May 22, 2015, while the election petition was pending before the Minnesota Supreme Court, signed into law the repeal of that tolling requirement, and only for federal legislative election, the tolling provision remains for state legislative elections. This tolling provision is absolutely necessary to comply with the requirements of the U.S. Constitution and a Republican form of government. The contest provision is constitutional, see Franken versus Palenti, precisely because it is in aid of the U.S. Senate and does not usurp its power. And yet, here is Governor Dayton attempting to weaken the constitutionality of the entire contest provision, which was challenged in Franken 1 in 2009 to get in the U.S. Senate. For how could the state hold up a recount and send a contest without it and not get complaints about Article 1, Section 5 preserving this kind of thing for the U.S. Senate? Although the state attempts to argue that its court had jurisdiction over the sole issue of which candidate received the highest number of votes legally cast and is therefore entitled to receive the election certificate. In other words, that means it still is reserved for the Senate. But even if the first sentences of 209.12 could properly be severed from the rest of the paragraph and the contest provision bifurcated, as Senator Franken's motion to dismiss sought in the Minnesota three-judge panel, it would still not be true that the contest had been finally determined by a court of proper jurisdiction. The use of the word determine is unfortunate because a Minnesota court does not have the power to determine any legislative contest, because that power resides in the legislative body itself. And this is as true for the U.S. Congress as it is for the state legislature. And so even if the term is taken as referring only to the actions allowed to the Minnesota courts and canvassing board, that is to say, to aid the Senate by counting the votes and collecting any evidence in any contest, and forwarding it to the U.S. Senate, the final determination lies with the Senate sitting as judges. In addition, the state proceedings provide for appeal. The Minnesota courts have not finally determined the case until the time for appeals has run or an appeal has been finally determined. But most significantly, the contest cannot be finally determined, and even the courts called it partial findings. And partial findings did not finally determine a contest on December 19th. The contest was whole, not partial, and the power does not lie with the three-judge panel appointed by the Minnesota Supreme Court Chief Justice, to either suspend the requirements of the tolling provisions nor to determine a partial contest. It is the duty of the United States under that Constitution to secure valid elections when necessary, as stated at Article 4, Section 4, Clause 1, the Guarantee Clause. The United States shall guarantee every state in this Union a Republican form of government, identical. This court is to guarantee free and fair elections in Minnesota. That duty is shared with the U.S. Senate and the U.S. House of Representatives, because all of you act as judges in elections for Congress. Since 2012, the Minnesota Supreme Court has refused to enforce the election laws needed to meet the requirements of a Republican form of government in Minnesota. The Minnesota courts have, since Franken's 2009 court victory, usurped the power of the U.S. Senate, carried out a procedure designed to thwart Minnesota election law and the Constitution. Now, commands of this court to the Minnesota Supreme Court in White, 2002. The legitimacy of this court ultimately rests upon the respect accorded to its judgments. That is Justice Kennedy concurring in Republican Party of Minnesota, Republican Party of Minnesota versus White. That was the U.S. Supreme Court case in 2002 in which this very Minnesota Supreme Court was involved. And Justice Kennedy continued, that respect flows from the perception and reality that we exercise humility and restraint in deciding cases according to the Constitution and the law, unquote, cited by Chief Justice Roberts in dissent in Obergefell. This is also true of the Minnesota Supreme Court, who in fact was the selfsame court that was overturned in White Supra. In reversing the decision of the Minnesota Supreme Court about their own election practices, this court found the First Amendment does not permit Minnesota to leave the principle of elections in place while preventing candidates from discussing what the elections are about. Citing Renee versus Geary, 501 U.S. 312. As in White, the practices challenged in the election contest and election petition dismissed in the court below include the Minnesota court's refusal to regulate the elections through laws prescribed by the state legislature. The challenged practices, quote, burden a category of speech that is at the core of our First Amendment freedoms, speech about the qualifications of candidates for public office. And that was White at 3, and in Anderson versus Celebreze, this court has been explicit in its command that states, including state courts, quote, it is to be expected that a voter hopes to find on the ballot a candidate who comes near to reflecting his policy preferences on contemporary issues. I'm leaving out citations here. The right to vote is heavily burdened if that vote may be cast only for major party candidates at a time when other parties or other candidates are clamoring for a place on the ballot. I guess my party and I were clamoring to get in that debate. So there was clamoring going on, and now we're clamoring to get on the ballot, yes. The exclusion of candidates also burdens voters' freedom of association, because an election campaign is an effective platform for the expression of views on the issues of the day, and a candidate serves as a rallying point for like-minded citizens. Although these rights of voters are fundamental, not all restrictions imposed by the states on candidates' eligibility for the ballot impose constitutionally suspect burdens on the voters' rights to associate or to choose among candidates. We have recognized that as a practical matter, there must be a substantial regulation of elections if they are to be fair and honest, and if some sort of order rather than chaos is to accompany the democratic processes. To achieve these necessary objectives, states have enacted comprehensive and sometimes complex election codes. Each provision of these schemes, whether it governs the registration and qualification of voters, the selection and eligibility of candidates, or the voting process itself, inevitably affects, at least to some degree, the individual's right to vote and his right to associate with others for political ends. Nevertheless, the state's important regulatory interests are generally sufficient to justify reasonable, non-discriminatory restrictions. Constitutional challenges to specific provisions of a state's election laws therefore cannot be resolved by any litmus paper test that will separate valid from invalid elections or restrictions. Instead, a court must resolve such a challenge by an analytical process that parallels its work in ordinary litigation. It must first consider the character and magnitude of the asserted injury to the rights protected by the First and 14th Amendments that the plaintiff seeks to vindicate. It must then identify and evaluate the precise interests of the state put forward by the state as justifications for the burden imposed by its rule. In passing judgment, the court must not only determine the legitimacy and strength of each of those interests, it must also consider the extent to which those interests make it necessary to burden the plaintiff's rights. Only after weighing all these factors is the reviewing court in a position to decide whether the challenged provision is unconstitutional. The results of this evaluation will not be automatic, as we have recognized there is no substitute for the hard judgments that must be made. Now, the election petition dismissed raises the same challenge practices, but also points out the present legal duty the Minnesota court had, and I would argue still would have after the governor signed a new bill changing the state law, to withdraw the election certificate of Senator Franken because an election contest was still pending December 19, 2014. As the Minnesota Supreme Court did in the 2014 re-election of Senator Al Franken, Minnesota, left the principle of elections in place, but prevented candidates from discussing what the elections were about. This occurred by limiting the First Amendment freedom of association and political expression during an election by abridging. For this reason, the petition should be granted, and Minnesota should be called to explain what it is doing in its elections, and the Minnesota Independence Party should be put back on the ballot as a major political party. Further, these practices of stifling elections by the DFL and its officials and by the Minnesota Supreme Court need to go before the U.S. Senate and the U.S. House under the prescribed laws of Minnesota, mandated by the broad grant of authority and responsibility of the Constitution, Article 1, Section 4, and the requirements for the U.S. Constitution for enforcement of election laws. Minnesota violated the principles of elections. The objectionable voting rights practices of the DFL, which started the ball rolling in 2012, which caused a change in the practices of the OSS to make voter email addresses available for many years, and caused a crackdown on contests abusing IFP, filing fees, threats to not file for IFP again, illegal release of the certificate after the 2012 contest had been filed, and then the total exclusion from debates, deliberate issuing of the election certificate while a viable contest was pending December 19th, and now the total elimination of the protection of tolling provisions to make Minnesota congressional election contest provision constitutional for any contest. These grew out of a concern for quotas and for commitments to quotas by the Democratic Party, and as I've already said, by the state, backed by state law. Now, even the Democratic National Committee, which recently met in Minneapolis here, sets up barriers against quotas and discrimination, which the Minnesota DFL, who does not rely on any history of discrimination to justify it, readily embraces as a political strategy and tactic, an exclusionary strategy and tactic. Look at Appendix E, the Dnc Rules, starting with Rule 5. In order that the Democratic Party at all levels be an open party which includes rather than excludes people from participation, a program of effective affirmative action and inclusion is hereby adopted. Discrimination on the basis of status in the conduct of Democratic Party affairs is prohibited. In order to continue the Democratic Party's ongoing efforts to include groups historically underrepresented in the Democratic Party's affairs by virtue of race, ethnicity, age, sexual orientation, gender identity, or disability, each state party shall develop and submit party outreach programs, including recruitment, education, and training, in order to achieve full participation by such groups and diversity in the delegate selection process and at all levels of party affairs. This goal shall not be accomplished, either directly or indirectly, by the party's imposition of mandatory quotas at any level of the delegate selection process or in any other party affairs. 2. In the selection of each state's at-large delegation, priority of consideration shall be given to African Americans, Hispanics, Native Americans, Asian Americans, and Pacific Islanders, and women, if such priority of consideration is needed to fulfill the affirmative action goals outlined in the state's delegate selection process. Such remedial action is necessary to overcome the effects of past discrimination. Use of the at-large delegation to fulfill the plan's affirmative action does not obviate the need for the state party to conduct outreach activities such as recruitment, education, and training. Priority of consideration shall also be given to other groups, as described in Rule 5C, which are underrepresented in the Democratic Party affairs, in order to assist in the achievement of the full participation by these groups. And yet, as I testified in federal court, that I have experienced myself in DFL precinct caucuses, and by the way, I testified this in the 3-judge panel too as part of this contest. The state does use mandatory quotas. I testified also to the 3-judge panel under oath for the Senate that I was asked if my Chicano friend would get off the delegation the year Amy Klobuchar was first elected because we had too many men and that violated DFL laws and rules. He remained because he was a minority. I was his proxy. The Texas Democrat Rules, Appendix E, explicitly require no test of membership in nor oaths of loyalty to the Texas Democratic Party shall be required or used if it has the effect of requiring prospective or current members of the Democratic Party to acquiesce in, condone, or support discrimination on the grounds of race, sex, sexual origin, gender identity. The state should have to justify this burden on the individual voters, even those who might otherwise attend a DFL caucus, and explain what is really going on here. This is a layer upon partisan redistricting which drives really extreme political divisions. This is only right for a democracy. And yet in Minnesota, under the participation statute, the Minnesota court said the Senate can't talk about this. This is a principle of the Minnesota DFL Constitution, which all must agree with to attend or vote in a precinct caucus. In other words, you can't show up if you don't agree with this. And the right to vote in precinct caucuses is secured in the state's constitution. Elective franchise, Article 7, Minnesota Constitution. The DNC even defends in advance its mandatory quotas. Quote, notwithstanding paragraph A2 above, equal division at any level of delegate or committee positions between delegate men and delegate women or committee men and committee women shall not constitute a violation of any provision thereof, unquote. But this court is not bound by that provision, and this case challenges this practice in Congress and the courts. At the very least, under Anderson, the state should have to justify this burden. Minnesota's DFL Constitution violates restrictions against both quotas and oaths to vote based on status. Quote, the state party chair and other DFL party officers at every level shall by affirmative steps encourage all Democrats to select affirmatively such individuals when voting so that such groups shall be represented on such delegations and committees and in party offices in reasonable proportion to their presence in the state. These affirmative steps shall provide a basis for review and challenge of officers and delegations as specified in the bylaws and printed in the call to convention. As my very serious rap says, up here we've always talked about integration, but instead we're spreading quotas all across the nation. I hope that at last I have found a court that will allow this practice and the other nefarious practices that come out when you challenge it to be widely known and examined and changed. Conclusion. For this reason and reasons argued infra, the court should 1. Request a response from Minnesota to this petition, and then 2. Grant the petition and reverse Minnesota's decision and remand it back to the Minnesota High Court. 3. With instructions to command the governor to void the election certificate for being unlawfully issued December 19, 2014, while a contest was pending. 4. Void the election results and restore the major party status lost as a result of those results. 5. Strike down as unconstitutional the new 2015 law repealing the tolling provisions during contests. 6. Reopen the contest under Minnesota law to certify evidence on the challenge practices and invalidity of the election. And 7. Allow it to go to the Senate for disposition. 8. Restore the Minnesota Independence Party as a Minnesota major political party pending the disposition of the contest. The petition for a writ of certiorari should be granted. Respectfully submitted, Stephen Carlson, September 14th, 2015. So that is a reading of this. If you stuck with this far, I appreciate you looking at these legal questions. I think you'll find it applies to your state and to the entire nation's elections. I'm running for president. I want to get on the ballot in Minnesota. I want to get over 5%, and actually I want to challenge the candidates for president, and I don't believe that Minnesotans are just going to try to get 5% if a credible campaign and a credible candidacy is not put forth. As such, I am also campaigning and trying to get on the ballot and get voted for in every state in the Union. And I hope that all other independent parties, third parties, will also look to this as protecting their rights and will work this year to put your candidates for president in every state, in this state. And I look forward to talking to people around the country to see if I can get on the ballot in your state with your support. Again, I'm Steve Carlson. I approve this message, and thank you very much for your attention.